In Texas, we have really two different types of custody, which is your joint managing conservatorship, which is where most courts default to, and sole managing conservatorship. Both of those go to decision making for the children, such as who's going to determine the primary residence of the children, invasive medical decisions, educational decisions, and psychological or psychiatric decisions for the children. Typically, if it's a joint, then both parents would make those decisions together, or we can have independent, where each parent would make those decisions when they have the child, or we have one party gets to make the final decision after talking to the other parent. In a sole managing conservatorship, one parent would make all of those without having to talk with the other parent. So in family law, courts will look to the best interest of the child to determine certain things that will affect the child. And there are a list of many, many different factors that the courts will consider. If the child's old enough, then they'll consider what the child would like to see happen. And typically that's an age 12 or older. We have, who will keep the child's best interest and what's best for the child in front of what's best for themselves better. They will look at which parent would be able to work the best with the other parent. They'll look at factors as, have we had any false reports to Child Protective Services? There's many, many factors that they'll look at. In Texas, we're allowed to change or modify custody orders as long as the child is under 18 or still in high school, whichever comes later. We call it a modification of orders. Once again, the courts are going to look at the best interest of the child and if we've had any danger to the child that's occurred. It's not easy to change conservatorship in Texas, but it can happen. And if we have a child that's 12 or older, they get to go and talk to the judge and actually tell the judge what they would like to see happen. And that holds a great amount of weight in our courts. In Texas, we have what we call geographic restriction on the residence of the children. That has to be requested in court. If it is requested by one parent, it is typically granted. And that means that the child's residence has to remain in a certain location. It's usually the county that they're in and any county that touches it. If you want to move within that restricted area, nothing else has to be done with court. If for some reason you want to move like to another state outside that restriction area, you'll have to go back to the court and prove to the court it's in the best interest of the child to be moved away from the other parent if they're in that general location. If neither parent, or if the other parent doesn't live in that restricted area, then it's fairly easy to be able to get that geographic restriction lifted. Otherwise, the courts will have to make that decision on the best interest of the child and whether or not you can move the child outside the restricted area. So in order to move the child outside of the restricted area that has been granted by the courts, you would have to prove to the court that it's in the best interest of the child, not yourself. Courts will typically look at socioeconomic factors, how involved the other parent has been in that child's life, where the other parent lives, where extended family lives. So there's several factors that will be looked at to see if it's in the best interest of the child for you to be able to move outside of that geographic area. If you have any questions at all, or you're facing a custody battle and you want to know what your options are and what that might look like for you, please give us a call at the Boswell Law Firm.